Okay, I have you all muted. If you want to talk or ask questions, just unmute yourself and then, um, you can speak to me, but trying to block out as much background noise as possible because Nestor is recording this to be placed on the YouTube channel that we have. There's a link to that in your emails you receive if you want to see prior sessions, including last Monday's session if you missed that. Okay. No, that one wasn't recorded. I'm sorry, but it was just a repeat of things we had done before. Okay, we have quite a few people on here. We're going to go ahead and get started. If you would make sure you pull out that citation schedule. There's other information that we can address, but the citation schedule is what I want to concentrate on today. So if you're not familiar with our citation system at NVAR or national level, actually, then let me share it with you. They have taken items that are prima facie provable on face, okay? And they said, you could go ahead, if you want to have a hearing, you could go ahead and have a hearing, or if it's eligible and the grievance committee will allow it, you can just pay a fine, call it a day, skip a hearing, and move forward. Now, why would someone want to just plead guilty and skip a hearing? Well, if it's provable on face, what are you going to tell a hearing panel that I might be on or chairing? What would you tell us that would convince us that you didn't have to follow all the rules and regulations of the law? So, if you did it, admit it, pay the fine, move forward. Okay. And if you're not familiar with the system, the charge is filed with the grievance committee. They don't make a decision whether you're guilty or not. All the grievance committee does is they take the information sent by another agent or a member of the public, and they say, if we take this information as true on face, could there have been a violation? If so, we will send it forward to a professional standards committee, or if it's obvious, then we'll give them opportunity to pay and skip. Okay, skip the hearing. I am on the professional standards committee, for lack of a better word. That is the jury. I'm actually February chairing one of the hearings. So I would never do a hearing involving Fairfax Realty agent, of course. They would dismiss you from the panel. But if you're ever charged with an alleged violation of the code of ethics, I will go with you to the hearing. If I think you you may not have done it, but if you were guilty, I'm just going to tell you to pay up. I don't go to try to get people off. Okay. I've got a pretty good record so far. Everybody I represented from Fairfax Realty, if we went to hearing, we've won. So I'm a pretty good person to have on your side when it comes to this code of ethics. Now, let's go ahead and take a look at we're just going to go through this list. So you get an understanding of things that are provable on face. Now, another reason not to have a hearing, what is the maximum cash fine that an agent could be fined? It is now $15,000. Now, it's not going to happen for your first offense, that type of thing, but it's up to $15,000 now. So let's just take a look. Hopefully everybody has found a citation schedule. SOP, standard of practice. So the code is divided into 17 articles, and then they have SOP, standards of practice, to support those. So 1-5, failure to disclose dual representation and obtained informed consent from both parties. Look, you either have, if you did a dual agency, you either have the form signed or you don't. Why would you want to argue? If they give you an opportunity to pay $500 for your first offense, go ahead and pay it, because you could have also been charged with Article 9 for not having it in writing, and now you see it just starts adding up. Now, I want to point out, if you go to the bottom left-hand corner of the citation system, this is a big change for 2020 when they redid this. If you see an asterisk after the money, so if you went to the first violation of 1-5, the fine is $500, but with a single asterisk, if you will go and take an ethics class, they will cut that in half to $250. So basically, we never had a second and third violation. You were automatically going to go to a hearing. Now you'll see with a second violation, 2 asterisks. That means you will pay the fine and you will have to take a class. Okay, and same way with the third violation. Now, if you're getting that many violations for the same thing, they may not give you the opportunity to pay. They may say you have to go to a hearing. Now, you have to add $250 to each one of these fines that you see in the citation system, and that's processing cost. Okay, so 500 plus 250, but they'll knock off 250 of the 500 if you will take a class. Okay, so dual agency, I think we pretty much understand. You have to tell people in advance, and you have to get their written permission before the transaction begins. Now, 1-7 is one that people may not know. Failure to disclose written affirmation as soon as practical that an offer was presented, or that the seller landlord waived the obligation to have the offer presented upon written request of a cooperating broker, okay, submitting an offer. So you're quite often, I hear, we don't think they presented our offer. Our offer was higher and the owner took less money and it was the listing agent. Well, it's up to the owner which one they will take. And before, you had no recourse. Now your broker, you could go to your broker, your manager. That manager submits the written request to the other broker. They have to then answer, yes, it was presented, or no, we had instructions to not present it. Now, it doesn't help the buyer and get the property, but at least now you will know that your contract was presented. And if they don't respond, then it's 500, 1,000, and 3,000. You know, so it gets more expensive as you go along. Everybody understand 1-7. It's just an avenue for us to feel more comfortable that it was presented. Now, make sure you understand this code of ethics is only enforceable against a realtor. That is someone who belongs to an association. Not all real estate agents are realtors. So if it's a firm outside of NVAR or another association, then this does not bind them. 1-12, okay, failure to advise the seller of information regarding their listing. So Code of Ethics 1-12, and it just simply says, go over these items with a seller. Your company policy regarding co-op and the amount of any compensation. The fact that the buyer agents or brokers, even though they're representing the buyer, will be not bound by their loyalty, etc. So buyer agents are, even if we're going to be giving them some of the money, that doesn't mean they're working for you. And any chance of you becoming a disclosed dual agent. Now, 1-16. This is an unusual one, and I like to link it to 3-9 down below. A listing broker accessing or using or permitting anyone to enter a property under terms and conditions other than what the owner has agreed to, or the landlord. So what do they mean? Well, in the listing agreement, okay? So in our listing agreement, if you had the listing agreement in front of you. It would be page 4 of 12. And it says, broker agrees that the showing instructions to be shared in the MLS with other real estate brokers and their prospective buyers are as follows. It could be vacant, lockbox, call listing agent before showing, okay? But you're the listing agent. You can't be there when the party wants to see it. So you say, I tell you what, it's vacant. I trust you. Or it's one of your clients that are buyers. I'll just leave a key under the mat, okay? Because I can't meet you there to open the door. So they use the key under the mat, and lo and behold, who comes along and sees somebody in the house? The owner of the property. And they go in and they say, well, who are you? And he said, well, the agent left the key under the mat. Okay. Well, that wasn't the instructions, right? So that's $1,000 fine. Now, 3-9 is a little different, and that is a co-op broker providing access or entering a property other than the terms given. So even though it said call first, lockbox, vacant, call listing agent, you can't just go in there without calling the listing agent or the showing service or whatever. That wasn't what was the instructions of the owner. You say, well, it's vacant. What difference does it make? Well, you still have to follow the instructions. Any problems with any of that? Any questions about any of that? Because I'm going to tell you, we get quite a few of 3-9 complaints at the association. Usually the agents just pay the money, but we've had hearings for 3-9 because they also felt it was an endangerment to the public in what was done. Usually when we get it at a hearing panel, it was a property that was not vacant, and people walked in on other people.
Larry, I have a question about that.
Okay.
I've had instances where I was leaving a property, another agent was showing it or arrived to show it, or in reverse, where I'm arriving, the other agent was leaving. And there were instances where there's a question about how to allow the other agent to come in, or I'm just not aware if there is a rule that says
there is a rule.
There is a rule. Okay.
Okay.
Could you discuss that situation, please?
Sure. And it would be under regional rules and regulations for lockbox systems. But here's the deal. You have to lock the house up. You have to put the key back in the box and make the agent use their key to get back in. And there's several reasons why. One, how do you know that's even a real estate agent? You know, that you're leaving the house open for. And two, if I check the lockbox and you're the last person who used the key to get in the house, you're on the hook. Okay, because the owner only authorized access by use of the lockbox, not by somebody else letting them in. So you always apologize to the agent. I can appreciate the fact that this is a pain for you to have to do this, but that's what the rules and regulations are. Okay, it says it, and we'll see under regional rules and regulations, you have to maintain the key at all times. Okay, so do not let somebody else follow you in, or do not go in. Tell them, thank you very much, but let me put my card in the box or whatever. And pretty soon there won't be cards; it'll all be codes from iPhones, right? But yeah.
Right. So just to follow up, and I think I know what the answer is, but it would be more of a situation where I would put the key back. This happened just once. I put the key back in the lockbox, locked it, but the door was still open and they were able to enter, and they would have to then open the lockbox to retrieve the key and lock the door. So, but I think I know what you'll say for that.
it also says under the regional rules and regulations for lockbox systems, you have to leave the house the way you found it. So if you unlock any doors or any windows, or your parties do, you have to lock them back up, including the front door, and make them use their key to enter.
Okay. Okay, thank
Okay.
you. Yes,
Okay.
thank
And thank you for asking those questions, because I'm sure other people have it, and a lot of people are afraid to speak up and ask them. So this is a perfect time for asking those kind of questions. Okay. Now let's go to Article 3. Okay. Now there's none under Article 2 of the Code of Ethics that fit the citation system, because that's property disclosure, et cetera, murder, suicide, ghost, no material adverse facts, that type of thing. But let's go to Article 3, 3-2. As a listing broker attempting to unilaterally modify the offered compensation with respect to a cooperative transaction after realtor has submitted an offer to purchase or lease that property. When you enter something into Bright MLS and you put compensation, you have guaranteed that compensation. I don't care what you put in the remarks section or anywhere else, you guaranteed that compensation. Okay. So when we present our offer, remember when we looked at the sales contract, the first blank in the sales contract is date of offer. And remember, in a contract, when you have quotation marks around a word, that is setting a definition. So date of offer is the date that you're writing the contract. Paragraph 24 of the sales contract says we're guaranteed the compensation that was offered on the date of offer, and that's that first blank. So a broker cannot call back, or an agent cannot call back and say, well, I'm sorry, because the bank just said no, unless the commission's lowered to this amount of money, so you have to take less money. It doesn't work that way. That's unilateral. It has to be in a written agreement between the brokers. Agents can't negotiate the commission, so that would be something that's broker to broker. But for them to come back and say, if you don't do this, it's going to be a violation of the Code of Ethics. Okay. 3-4, failure to disclose the existence of a dual or variable rate commission. Let me just quickly explain what a dual or variable rate commission is. It is covered under 3-4 of our Code of Ethics, and we get this one quite often charged at the association. You come out to my house, and I'm not going to use numbers because we might have guests on here from other companies. So bear with me here. I don't want an antitrust violation. X% total. The total commission is X%. Okay. We'll keep Y, and we'll give co-op broker Y. However, if we sell it in-house, if I sell it, another agent in my firm sells it, then we'll do it for W. And if you subtract W, what you get if you sell it in-house from the total compensation, it's 1%. That is a variable commission. If you have this agreement with the owner up front, you must tell everyone in our association that you have this agreement. Now, the way we do it, variable commission is one of those that required in the input sheet. If you have this agreement, it's yes. Now, 3-4, the Code of Ethics says, you as the buyer's agent, okay, you as the buyer's agent have the obligation to check every listing before you write a contract to see if it's a variable commission noted. If so, you must call the listing agent, you must ascertain the differential, and you must tell your buyer client before they write an offer. Okay, that's also included in 3-4. But what this is saying is failure to disclose it. Now, this has to be an agreement up front. It's not where if two agents, a listing agent wrote a contract and the buyer's agent from another firm wrote one, there's nothing to prevent, okay, there is nothing to prevent that listing agent from negotiating the commission change right there at that presentation. That's not a variable commission at that point. But from that point on, there, if neither contract was ratified, then that would be a variable. So this is agreed to up front. So if you ever have that agreement, make sure you do it. Now, in our listing agreements, okay, with the seller, okay, listing agreements under broker compensation, paragraph 12C, variable rate commission. If applicable, the broker and seller agreed to a variable rate commission to be paid as follows. And you spell it out, 1% less if, in-house sale, whatever. But once you fill that part out in your listing agreement, you have that variable rate. You must now disclose to everyone, and you must disclose the differential if they ask. Okay. Everybody okay with that? Variable rate. Okay. 3-8, misrepresenting the availability of access.
Sorry, Larry, can I ask you a question?
Okay.
You said if the agent from the same office buying the house, what else could it be? What kind of variations?
That is what a variable is. That the commission will be less if it's a co-op sale than an in-house sale.
Okay.
And that's for purposes of our citation system and our code of ethics. That is it. Okay?
Nothing else.
No. Well, let me read it to you from the code of ethics. Okay. And I think you have a copy of the code of ethics, but maybe not in front of you. Realtor acting as listing brokers have an affirmative obligation to disclose the existence of dual or variable rate commission arrangements. In other words, listings where one amount of commission is payable if the listing broker's firm is the procuring cause of sale, lease, and a different amount of commission is payable in the sale lease results through the efforts of the seller, landlord, or co-op broker. So that's what it lists as a variable commission. Variable, and a lot of agents think variable commission is the listing broker kept more of the commission than they gave us. That's not variable. Okay. That's a decision between the owner and the listing agent as to how the commission will be dispersed to other parties. Okay. So it has nothing to do with one party. One agent got more than the other.
So Larry, I have a question.
Okay.
Say that I have a listing and the same brokerage agent brings the buyer, then do I have to have a variable?
No.
Okay.
A lot of agents use this just as a listing tool, so that the owner, will get a little break if we produce both sides, But no, you don't have to. It's only if you've agreed to it under paragraph 12C of the listing agreement.
Okay, if that we agree, then how will it work? Then say that commission is 5%. We say that 5% commission.
No. There's a question on the input sheet that says variable commission, yes or no.
Okay.
If you have this agreement, you answer yes.
Okay.
If another agent calls and asks you what the variable is, then you tell them that, it's 1% or whatever the difference is between an in-house sale and a co-op sales total compensation.
Then question. I'm sorry. Okay. How does it work if it's like the unrepresented buyer and I am the seller's agent? So does it have anything that needs to be disclosed as to commission?
If you're representing the buyer, you have a buyer broker agreement.
Okay. Yes.
Okay. Then
but I'm also the seller's agent, remember, okay?
Well, it wouldn't be an unrepresented party if you're the seller's agent.
That's what I'm asking. If it's an unrepresented buyer, okay? And
unrepresented buyer, okay? And you're representing the seller?
Yes.
there's nothing to disclose to anybody. And
Okay.
you're still entitled to the total compensation of your listing agreement.
Okay. All right.
Okay.
Thank you.
Okay. But let's talk about that FSBO for a second. You have a buyer broker agreement and you're going out to for sale by owner's house. Our code of ethics says you must ask for the compensation at first contact, not first contract. So if you're dealing with a member of the public whose home is not listed, you need to get them to agree to that compensation up front. Okay, and remember, you need a right to show, the compensation, and unrepresented party form signed. Okay, and our code of ethics does call for that, all three of those.
And in this case, you have to write unrepresented party agreement with the compensation on it.
Correct. Right. It says ask for you have to ask for all compensation at first contact, not first contract. Okay.
Yes, thank you.
Okay, and 3-9 we've already discussed. Article 4, failure to disclose your interest in a property being bought or sold. You know, there's a blank in our contract, and you always have to disclose if you are the buyer or seller, right? So we don't need to discuss that one. Article 5, providing professional services without disclosing that your present interest in a property. That one we never really see. I don't even know why it's here. But if you were asked to do a CMA for a property that you're not the agent for, and you own 2 other properties in the same neighborhood, you might do a CMA, or you could actually do, BPOs, etc., for a higher amount so that the values of your property are higher. We don't really see that one, so I'm not going to worry about that one. Article 6, the first paragraph of Article 6, accepting any commission, rebate, or profit on expenditures without client's knowledge or consent. If you're getting paid some money for everything that you do. And the second is also one that we don't see too often, failure to disclose to a client financial benefits or fees that you might receive. So let's say that you recommend a moving company and they give you $100 for each person you send. You could probably take the $100, but you'd have to disclose to the parties beforehand that you were getting that $100 for that referral. Okay, be a violation of the code of ethics. I'm actually doing my continuing ed for my Florida real estate broker's license, and that was just one of the questions on the exam that I had to do. Yeah, we have to take an exam down here and pass it to renew our license, not just sit in a class, right? The next one here, 6-1.
Larry?
Yes.
Sorry, I want to ask you a question. If you're just helping the client to find a contractor to do some job, you need to disclose something, or only if you're getting money out of the contractor?
You don't have to disclose, but be very careful how you recommend someone. Make sure they are licensed and bonded contractors, because if they're not, it's going to come back on you. And I'm not talking ethics. I'm talking about them suing you. So, I always recommend more than one contractor. If you have list, then you can have a preferred list, but be careful. I'm going through something right now because the buyer's agent chose the lender, and people didn't get turned down for their mortgage in time, and they were in default, and people are threatening to sue and everything else. So be careful who you recommend and make sure they are licensed and bonded. Okay.
Thank you.
Okay, Article 12. Somebody else have a question?
Yes, sir. Yes, there is. How about if you're referring 2 people instead of 1?
I always recommend multiple people and tell them, you know, these are people we've dealt with that have been, had good luck with. You know, you can use one of these, but also you have the right to choose another one. Be careful how you're choosing the people.
I mean, it's just if I give two lenders to my client, I don't think there's a problem with that. If I give one, that's a problem, right?
But if you're choosing the party, it can be a problem.
Okay.
Okay. So even though I use Doug Inger on everything that I do, I tell them Doug's been the loan officer on everything that I bought, my kids bought, anybody in my family's bought, you know, and I prefer working with Doug, but you have the right to choose whoever you want.
Thank you so much.
And I do recommend, you know, I have several other people that I recommend. Okay.
All right. Thank you much.
Good. That's a good policy to follow. Okay.
Larry, I have a question.
Okay.
It's on Article 4. You say the realtor has to the disclosed. So how do we disclose? Is that something in writing or just tell the listing agent or buyer agent?
No, it has to be in writing. And Article 9 of our Code of Ethics says everything has to be in writing. So when I teach ethics, you know, Article 1, Article 1 is cited by just about everybody because that's agency and ethics. But more people are found guilty of Article 9 than any other article because it wasn't in writing. So Article 9 says everything has to be in writing. Okay. So in our sales contract, there is actually a blank that you fill out that you are the what?
Oh,
You know,
okay, I see.
you are the buyer or the seller in your, you know, et cetera. You should also disclose any relationship to a seller, a relationship. Now, buyer's agency, I still recommend you do it, but you know, buyer's agency, by the fact that you're the buyer's agent, saying you're looking out for the buyer. Okay, so seller, you could still have a customer on a company listing, so always disclose that in writing. And there's blanks for it in your contract. If not, you know, something, you know, if I'm going out to a FSBO and the party I have with me is relative, or I'm looking on my own behalf, that disclosure is going to be right in that paperwork I give them up front.
Oh, okay, I see.
Okay.
So basically, the seller, the listing agent as the owner, just listed under the bright. It says agent owner.
Yes.
As buyer and owner.
Yes.
No, buyer agent and the owner just listed.
Yeah, buyer's agent. I always disclose if I'm related to the buyer, you know, just for protection purposes. And you could write that in there, but I think the contract is only for the listing agent.
Oh, okay. Thank you, Larry.
Okay.
It's in bright under disclosure.
Yeah. And it's also in our sales contract for disclosure, right?
Oh, okay.
Okay. Good. All right, so let's take a look at Article 12. This is truth in advertising. Failure to present a true picture in your real estate communications and advertising, and failure to disclose status as a real estate professional. So true picture. This is what the listing said. I had a young green architect looking to buy a house, and she wanted a green features in a house. And in the ad read, green was capital letters. House completely green. So, and we had to go right away. So we went right away to this house, and there wasn't even a CFL light bulb in that house. The only thing green was the paint on the outside. The house was completely painted green. That's failing to present a true picture in the advertising because the word green was capitalized. And she reported them to the Federal Trade Commission, and it cost the agent $11,000 for violation of green advertising. So she didn't take it so lightly. She didn't think it was funny as they did. Okay. I don't think they would do that one. Okay. And failure to disclose status as a real estate professional in advertising or other real estate communications. Okay, it doesn't matter if it's LinkedIn, Twitter, Facebook, etc. You have to disclose not only just for actual properties, it's your services also. Okay. So 12-1, failure to provide all terms governing the availability of a free product or service. My services cost you nothing. Okay. And I ran into this one in Florida many years ago when I was looking down here to buy. There was this full page ad by an agent in a Homes magazine that said, my service is completely free, no cost to buyers. So I called her up and asked her to come out to a property I was standing in front of that I wanted to buy. And she said, well, it's not listed, so I can't help you. I said, wait a minute. You said your services are free. I want you to come out here and write this contract. She wouldn't do it. So I reported her for false advertising, and her ads now say if reimbursed on your behalf by a third party. So give them a true picture in advertising. Okay. 12-4, advertising, offering to sell leased property without the authority of the owner. You know you have to have a signed listing agreement, right? And it can't be oral. It has to be in writing and signed by your broker. Until it's signed by the broker, you do not have a listing. Okay. 12-5, disclosed in 12-5, failure to disclose name of the firm in any advertising. Folks, I still see ads out there from agents with us that do not have the firm's name. You can't just have your team name. You have to have the firm's name in every ad. I don't care if it's LinkedIn, Twitter. It's not just when you're listing a property. If you're putting out something with somebody giving a testimonial, your picture, and it has only your team name, you are in violation of 12-5. Not only that, you're in violation of our depot rules and regs. That could have licensing ramifications for you. Please make sure you have the name. And on the sign, it must have the name of the firm and the phone number. Okay, the office phone number, not just yours. It's $500 for the first offense. You go back second time, it's $1,000 plus take a class, and $3,000 take a class. Now, you'll notice the little A. If you look at 12-5, you see the little A beside where it lists the violation. That means you can file a charge anonymously. If I take a picture of your sign and it doesn't have the right information, I just send over a copy of your Facebook post where you didn't have the company name or a link to the required disclosures. I don't have to, you won't know who did that. It can be filed anonymously. Okay. Now, if you want to know who did it, you could say, well, I want to have a hearing. Well, if you have a hearing, your fines are going to be much higher than stated here. These fines are less than what a hearing panel will fine you. Plus the cost for a hearing is $500. It's better to just make sure your advertising is properly.
Hey, Larry. Sorry.
Yes.
If my sign has the firm name, but with my phone number, is any problem?
That's a problem. It's got to be the firm name and the office phone number. Okay. Your name and phone number can be on the sign, but somewhere on that sign, and it must be what they call discernible. It must say, if you're Tyson's Fairfax Realty of Tyson's, on that sign and that office phone number.
Okay, because my sign, it's I don't have a sign, but I'm willing to have one. It says Fairfax Realty Select.
Okay.
So must have a phone number too. Huh?
It must also have the office. That's for signs, right?
Yes.
That go in the yard. Yes. Okay. And technically it could be a rider. Fairfax Realty of Select could be a rider with the phone number, but it has to be discernible so that the member of the public knows who the broker is, because they need to be able to contact the broker when they have a problem. And part of what brought this on, DPOR started getting complaints because people would call the name and the number on the sign thinking it was a broker, and it would go to a mailbox that says full. So they couldn't reach the broker, okay? Thinking that the person on the sign was the broker and that was the broker's phone number. So DPOR said no more. This is the law, and our code of ethics always said that, okay?
Mr. Larry, if you don't mind, please. You can have the sign of Fairfax Realty Select with the phone number, and attached to it in the bottom, for instance, your name with the phone number. There's no violation with that.
That's not a violation.
All right.
Or you could actually have your name and phone number on a sign and a rider that says Fairfax Realty and your office and the phone number.
Okay.
Nothing says you can't be on the sign with your phone number. It just says the public also has to know that you work with Fairfax Realty, and this is the number where you can reach the broker, basically.
Wonderful. Thank you, sir.
Okay?
Yep, got it.
Good questions. Good question. Now, internet and et cetera have different rules, right? It still has to have the firm name, but it doesn't have to have the phone number. Okay, so it can be an email address, et cetera. But so different rules for internet, but I'm talking about the sign in the yard. But all advertising must have that you are affiliated with the firm. Okay. And 12-5 is one of the big ones at the board. You know, we see a lot of that. Okay. Let's see, 12-6, failing to disclose status in both to landlord or tenant or licensee when advertising property in which you have an ownership interest. So anytime you run an ad, owner, licensed agent, okay, I think that's pretty self-explanatory, right? 12-7, claiming to have sold a property when not the listing broker or co-op broker. So if you're going to send something out about all these properties being sold in a neighborhood, you can do something that shows all the properties sold in the neighborhood. You can't just make it look like you sold them. Now, listing agents, the buyer agent has the right to say they sold the property, but they can't do anything with that until after settlement. Okay, so I could run an ad. I was listing agent of these properties, and I was the selling agent of these properties. There's nothing wrong with that, but don't make it look like every home in the neighborhood you sold.
Larry, I have a question.
Okay.
On the SOP 12-6, it said disclose. I was just wondering if I understand the sign has the agent's name and phone number and the firm's name and the phone number. Now, if the house is the owner agent, so do you need to also disclose on
it has
the
to
sign?
be on the, absolutely, it has to be on the sign, owner agent. And you know where it gets confusing is, say that I hire somebody else to sell my house for me, and I'm an agent, okay? It still has to say on the sign, owner agent, even though it's not the agent on the sign, because an owner still owns it. An agent still is the owner of the house, and the public needs to know that they are dealing with an owner. So even if you're for sale by owner and you're an agent, you have to make sure everybody understands you are an agent. The state law requires agent. Our code of ethics requires realtors to do the same.
Okay.
Larry, about 12-7, if I brought the buy and sold this house, can I claim that house had been sold with my assistance? I sold it.
Your assistant, is it a?
If I a buyer agent.
If you're a buyer's agent, and what? Your assistant.
Can I say I sold it?
Yes.
Okay.
After settlement.
Okay, yeah.
Okay. But, you know, and you haven't done anything wrong because you were, you know, you were part of the transaction. It was a co-op,
Yeah,
right?
yeah. Okay, I got it.
Okay. Good. All right. Let's look at 12-9. Failure to disclose firm name and state of licensure. So in your internet stuff, right, you would put in your signature block, it should have all the states that you are licensed in. So if you license DC, Maryland, and Virginia, it should state that. Okay. 12, 10, and 12, etc., deals with internet sites. And what I'm going to tell you with those, if you have a website and make sure the web developer knows what 10, 12, 13 say, because you don't want them to do something that would get you into trouble. So like framing, I've had people say on their websites, you know, Larry Anderson in a class said we should be the representative, you know, the advocate of the buyer. And I teach that in my ABR class. I don't mind, but other people might, because what you did is you used Larry Anderson's name in your website. That's called framing. So anybody that was Googling to find me, Larry Anderson, if it directed them to your website, that would be a problem. Okay, so just have the permission and make sure everything is done with them. I'm going to leave the websites at that. Okay. Now, Article 14. If you refuse to participate in a hearing before the board, it's going to cost you money, because everybody's agreed to do that under Article 14. Article 16. 16. Use the terms of an offer to modify listing broker's offer of compensation, or conditioning a submission of the offer on additional compensation from the listing broker. You don't like the compensation offered to you, the co-op broker, before you show the listing, you get something in writing from the other side, and it should be broker to broker, but it's usually not done that way, saying they will give you additional compensation. For you to write into your contract, your sales contract, this contract is contingent upon the listing broker giving the buyer agent additional compensation. That is a direct violation of the Code of Ethics. Not only will you not get that in an arbitration hearing, you will be paying $1,000 fine, okay, to do that. You understand? Now, there's nothing wrong with a buyer negotiating with a seller to give them a credit for whatever purpose, right? But you can't ask the listing agent to give anything up. Why? The contract is between buyer and seller. You're trying to negotiate with a listing agent with a document that we're not a party to, and you're interfering with that agent's agency agreement. So do not ever write that in there. I mean, that one is a easy one to prove, right? It's in there. You shouldn't have been. Okay. In 1619.
Larry?
Yes.
Sorry. You're saying that modifying the listing, right? What about if they put on the listing additional compensation? Let's say X% plus this dollar amount if it's a full price offer. It is against the Code of Ethics?
No, that's fine, because they're offering it. But you couldn't say, okay, look, I did a lot of extra work on this, so I'm going to write into this contract that they have to give me a bonus above the commission of $2,000. Okay, and I'm asking the listing agent to give it. So you can't ask the listing agent to give up any of their compensation in the contract. You can do it outside and discuss it with them. So if they offer a bonus, do you have to write it in the contract? No, because paragraph 24 says we're entitled to the compensation offered as of the date of offer. Okay, so you just need to have that as proof. But no, you can put in your listing bonuses, and they can offer bonuses, etc. Okay, you just can't ask for something that wasn't offered to you by the other side by asking in the contract for them to give it to you.
Understood. Thank you.
Okay?
I mean, we cannot, if we represent the buyer, we cannot ask for extra compensation.
Up front, before you show the listing.
Ah, okay. But if
but not after.
If I show the listing and I worked very hard on this case, and I said, listen, you know, I'm entitled to get more.
Well, you're not entitled to get
No,
more.
I mean, yes, but the listing agent agreed that I worked very hard, and she said, okay, you know what? We are offering to you additional 1,500 if you will bring the offer.
Yeah, now, and that would be between the two brokers, not between the two agents. So you need it in writing from broker to broker about the compensation.
Oh, okay.
Okay.
Larry, I have a question. Why someone will ask more commission? Why someone will ask more compensation?
Well, what if my buyer broker agreement says that the buyer pays me the money, which they do, and the compensation offered by the listing agent is less than what the buyer's agreed to pay me, then the buyer owes me the difference. Okay. So the buyer might say, do I have to still pay you the difference? Yes. Then I want you to ask that listing agent to give that money to you directly. If you follow that instruction and put it in your contract that the listing agent has to give me more money, that's a problem. Now, if the buyer's agent, so if I was doing this and my buyer agreement was more, I would approach the listing agent by saying, look, you know, my buyer client has asked to see if you would reimburse the additional compensation of X% on their behalf per our written buyer broker agreement before I take them out to your listing. That's fine, you know, but to go out there and then say, I'm not writing a contract unless you give me the extra money, that could lead to be a problem.
But then we have to tell buyer, this is the possibility. Otherwise, buyer will not ask that you ask other person to give the.
Well, sure. And I go over it with the buyer, you know, you've agreed me to pay this much. If the listing you want to see doesn't offer that much compensation, you're responsible for it, unless it's a VA contract. If it's a contract for a veteran and they're using a VA loan, they can't pay you anything.
Do you see often that people really listing agent entertain that idea?
Not really, but
not really.
not in this market. But you know, this market's not going to last forever. You know, and when it starts turning around where there's more listings than buyers, what's going to happen?
Right. And that at that time it might be possible.
Then you start getting bonuses and higher commissions and all kinds of stuff, right?
Right.
Yeah.
Okay, thank you.
Okay.
Larry.
Yes.
Larry, let's say the listing agent agrees, say, okay, then since you have like a 0.5% difference, yeah, we're gonna pay for it. So in that case, so what do we need to do? I mean,
you need to get an agreement between the brokers that there will be additional compensation. You do not write it in your contract.
Okay.
Okay.
Thank you.
Is email from the listing agent not going to be enough?
That's not enough. They could, because the listing broker may say, I didn't agree to that. Okay. And if the listing broker said, I didn't agree to it, what are you going to do? Because it's the listing broker's listing and it's the listing broker's client, and it's the listing broker's money until they receive it and give it to you.
Larry, question. This is nothing. This is not regarding this issue, but this is regarding some ethical issues. how am I
Okay.
going to handle the situation, which is in a most ethical way, where where a buyer wants to, he has his own agent and wanted my services. So what is it that I can do, or what is it that I cannot?
Well, you cannot interfere
Ethical
with an,
and legal.
you cannot interfere with another party's agency agreement. Now, if they want you, they need to go to their broker that they currently have, get that broker to release them, cancel their
Buyer broker
buyer broker agreement
is
for you
the
to,
email.
well, it's not enough for them to send an email. The broker has to agree, because they have a contract with that buyer. They have to agree to release that party. If not, they still owe the commission. Okay. You can't just send an email saying you're no longer my agent.
Mhm.
Now, I can fire you from being my personal services representative. I don't want you to represent me anymore. That doesn't mean that I don't still owe you money if I buy a house from somebody else.
Okay.
Okay. So if
Is there any
do not
form?
do not interfere with somebody else's agency relationship. You're just asking for trouble. Okay. And our code of ethics covers that, but not under the citation system. And it says you can't commit the same party to owing more than one commission by duplicating service. And that's what you'd be doing, because the
Okay.
buyer's not out of it just because they sent a notice, I don't want you anymore.
All right. Okay.
Larry,
And there is no form for that, for the
No,
no.
no.
Okay.
Larry, I got a
Yes.
question for you. Let's say an agent take a property out of the market. It's a problem if another agent contact the owners somehow trying to offer their services.
If it says withdrawn, okay, they still have a listing, so you cannot contact that seller. Unless it's canceled or expired, you cannot contact that owner. It's a violation of the code of ethics.
Okay, thank you.
Okay. And that's because, and that's why we have that new form. We no longer have a withdrawn form. They took that away because of the definitions under Bright. Withdrawn means it's still a listing. I just don't want you to have it in the MLS system. Okay.
Larry, I have a question.
Okay.
What happened to the, let's say, my next door neighbor, not next door neighbor, like a few houses down. I know the house been on the market for a very long time, and the other houses are selling. So I know what the problem is, but that the listing agent, they are not aware about what happened. So I'm thinking, I'm just asking a question about this. How do we handle it if I wanted to approach the owner?
You
Say,
can't.
okay,
You can't.
okay,
Okay. Direct violation of our code of ethics. Unless that
Okay.
owner contacts you and initiates the discussion
mhm,
about marketing their property, you just stay away.
okay. Not
Okay, you
even
just-
like the
No,
business
not,
card or anything like that.
no, nothing.
Oh.
Any contact will end up having you in a hearing.
I see. Okay, thank you.
Okay.
Laurie, sorry, one last question, but this is regarding loan. It's not on the ethics. On a VA loan, how does it work if, for example, my client would want, I know there's no way for him to weigh the appraisal or the financing, of course, not the financing, but the appraisal. How should I do that in the contract? Because on the VA, what's this financing contingency, I don't see anywhere there that says they can, waive the
They can't. It's against the law.
okay, for the VA.
Yes. It's against the law. But they can, after the appraisal comes in, they can proceed without, whatever the appraised value comes in, they can still proceed by using that appraisal contingency notice removal form that we discussed last week. Okay. But
Mr.
you
Larry,
can't wait. They can't waive it up front.
Okay.
Okay.
Larry,
Yes.
one final question for me. I'm a realtor, so if I want to do some mortgage stuff, it's any problems with that?
Well, you shouldn't be doing it on your own listings and your own buyers.
Okay, perfect.
Okay.
It's the only restriction that I have to think of, right?
Yeah, main thing. Yeah.
Thank you.
Okay. Now I want to look at the regional rules and regulations for lockbox systems before we call it a day here, because I think you might find some of this interesting. Now, regional rules and regs for lockbox systems. Remember, this also goes to the grievance committee. It's not just the code of ethics and to hearing panels. The first one, C, you have to remove your lockbox within 48 hours of settlement. Okay. If not, it's a fine. Okay. Shall keep the key in the holder's possession or in a safe place at all times. So I'm saying, don't just turn the key over to the other side and say lock up when you leave if they're following in. You're going to be held liable for that. So put the key back in the lockbox. Apologize for the inconvenience, but you know the seller needs to know everybody was in the property. Okay. G, shall not allow holder's pen to be attached to the key. So, you know, I'm getting up there in age. I'm 73. I might have a hard time remembering my numbers. So I write it on the key. Okay. If I get caught, that's a $500 fine. Shall not disclose or provide pen to any third party. So you download a code. Okay. Well, let's keep this simple. The next one is you know, don't lend your key out to anyone. So I know that an agent in my office has a key. They just forgot it. Their client sitting there, they want to go out and see that house immediately before they go to work. So I lend my key to them. That's an automatic fine of $1,000. However, could they get into the property without my PIN number? No. So that's an additional fine. Okay. So if you lend a key out, you're talking probably a couple $1,000 now if you get caught under the citation system. Now, I could go with them and let them in, but I can't give them my key. Okay. Now, the flip of that, you could download a code through the app. So if I download a code in Alexandria at 8:15 in the morning, and at 8:30 it's opening up a lockbox out in Loudoun County, how did I do that? Well, they know. They pinged when you downloaded the code. It pinged when it opened up the box. They've got you. That's a major problem. Yes.
Question there. You know, for example, if your colleague, for example, if my colleague, you know, made appointment to show a couple of houses to his client, but something happened and he called me, told me, hey, Haji, can you please go and open the door for them? Can I do that?
Yes, as long as you follow the instructions for showing. So if it said call first, lockbox vacant, call first, right?
Yeah.
As long as you follow the showing instructions, that's fine.
All right, thank you.
Okay. Now look at L. Shall not allow anyone who has been admitted to the property by the holder to remain in the property after holder has left the property without consent of the property owner. You know, you really want a Starbucks coffee, and the people, it's a vacant house, and you let your client in, and they just want to spend more time there. So you run down to Starbucks and get a cup of coffee. Meantime, the owner of the property stops by, and your people in there unaccompanied, or you have another appointment and they're already under contract, but they want to measure some stuff up. So you just left them in there and you get caught. That's a problem. Can't leave anybody in a house unattended. So what about a home inspector? You know, somebody's got to be there with them unless you have written instructions from the seller allowing that party to be in the house. Okay. M, shall close and lock any windows or doors opened or unlocked by the holder or by anyone admitted by the holder prior to leaving the property, including you have another agent waiting to come in. You still responsible that you didn't lock the door. And if TV's gone and stereo's gone and everything else, you got a problem other than just a fine of $1,000, right? So that is our citation system. Just remember, those are the ones that are provable on face. There's 17 articles to the Code of Ethics and a lot of SOPs that don't fit in here. Okay. Any questions about any of that? Any questions about anything else before we
Laurie,
sign off?
I have a question, not regarding this topic. I have a question regarding the PLE and CE, continuing education and past license education.
Okay.
So I think we, as a new agent for the first 2 years, within the first 2 years, just do the PLE, right?
First year. It's no longer 2. You have to have all 30 of those post licensing hours in the first year.
First year, only the PLE, right?
Correct.
Okay.
Continuing ed does not count for PLE.
Okay, so we have to do
And
both.
PLE doesn't count for continuing ed.
Okay, got you. Thank you.
Okay. Now, right now, because of COVID, they extend the period for the education without your license being, inactive, but get that education in. I mean, you have to do it by Zoom. Okay. I may be offering a limited attendance continuing ed again at our Tyson's office in the classroom we have. I might even do a session when I get back in February, but it's going to be very limited attendance. So because we need to space out 6 feet apart and follow all the COVID stuff. But if I do it, we'll get a notice out.
Okay.
Okay.
Right. Thank you. Thank you.
Larry.
Yes.
Larry, I have a question about this violation. So is that the other agent, let's say because of the sign that the office name is not there, so meaning the other agent called the DPOR?
It wouldn't be DPOR. This is NVAR.
Oh,
Now,
call it
DPOR,
NVAR.
it can be a DPOR violation also. I mean, it is a DPOR violation, but but DPOR is the licensing authority. This Code of Ethics is Northern Virginia Association of Realtors.
Oh, okay. So NVAR,
or whatever association you're in.
Oh, okay. Okay. So the other agent will call up the board.
Well, you wouldn't call, you would send over, if it's an advertising thing, you would send over an email with a copy of the advertising saying that, this is a violation.
I see. Or does it fine the agent, the person who calls, or get the money, or who gets the fine?
No, you don't get these fines go into the bank account of NVAR.
Okay. I was just curious about that.
Okay. So they go into NVAR's bank account to help offset the cost of the 2 full-time attorneys that the association has. Okay.
I see.
For dealing with this kind of stuff. Yeah.
I see. Okay.
So it's not just a money maker for NVAR, it actually helps offset the costs. And people like me on the hearing panels, we're all volunteers. We don't get paid. They just take well-experienced people and ask them to serve on these panels and hold these hearings so people get a fair, just hearing. Okay.
Larry.
I was going to cover the progressive, but this sort of shows it progressive nature of a hearing, but we can do a hearing process another session if you want to know more about it. But when we hold a hearing, we don't know if you've ever been found guilty of anything in the past. Okay. It's not until it's not until we actually have the hearing and it's determined that, in our opinion, you violated the Code of Ethics, before we would then assign the penalty. Then we would find out if it was a repeat. And then we have schedules that we have to go by and et cetera. And it all has to be approved by the board of directors. So it's quite an extensive process. Okay.
Larry.
Yeah.
Going back to the PL classes, I am
Uh-huh.
new and I registered for so many, but some of them were canceled as well. I don't know where to go to have the update of the classes that I took so I can take the ones that I didn't. Do you know where can I
Yeah,
get that information from?
go,
Thank you.
Google DPOR, DPOR, and do licensee lookup, and you put your name in, and it will pull your license up, and you can click on there, and it will tell you your education. Click on the education hours, and it will tell you what you have and what you don't.
Thank you very much.
It'll show you the actual hours you're missing.
Excellent. Thank you very much.
Okay. All right. Well, thank you guys for joining me, and pretty
Thank
good
you very
session.
much for
I
your-
enjoyed that one. So,
Thank you.
and
Okay,
I'll
thank
be.
you.
We'll
Thank
be
you,
back
Diane.
Monday with something. I'm not sure what, but we'll be back on Monday with something.
I like
Thank you.
that.
Thank you much.
Thank you,
See you,
Larry.
Larry. Thank you.
Okay.
Larry.
Thank you, guys.
you.
Enjoy the rest of your day.
You too. Thank you.
Bye.